Guys, welcome to this video. My name is John Watson. I'm a consumer protection lawyer. And Kenneth had a great question as a follow-up or a comment to a video where I was discussing about a recent lawsuit we'd filed against the 3 credit bureaus and a debt buyer. And his question is, it's been my experience that the debt buyer, and that would be a company like Midland Funding, Portfolio, LVNV, Jefferson Capital, but they simply dismiss the case prior to trial. And if they do that, what are the consumer's options as a result of the lawsuit being dismissed without prejudice? That's really key, without prejudice. So let's do a couple things here. Let's talk about with and without prejudice, and then talk about how they dismiss something without prejudice, and then what can you do as a consumer. So with prejudice, that's the good one. That means it's done, it's final, it's over. It's just there's nothing left to the case. So they cannot resue you after dismissal with prejudice. And at least where I practice, and I think in most states, it's considered an adjudication on the merits, which is just a fancy way of saying you won, okay? It's over. And so you never have to worry about them calling you, writing you, selling that debt, credit reporting on that debt. If they do any of those things, then you need to look at suing them, okay? Because the case is over in your favor. So that's with prejudice. Without prejudice means it's like they never sued in the first place. So they can refile the case against you. Now you have to look at your particular state. I'll tell you where I practice in Alabama. Imagine this is the statute of limitation. Here's where it starts. Here's where it ends. If they file right here and then they dismiss here, they still have time to file again, but no extra time. Now seems like maybe in Georgia they get an extra 6 months. I'm not sure about that, but there may be states where they get extra time. So let's say this is statute of limitation and we're in Alabama and they dismiss it without prejudice after the statute of limitation. Well, now they can't refile because it's too late. Okay. So how do they go about dismissing a case? Well, they file a motion to dismiss. Or they may have, I think in Georgia, they have sort of an automatic right to dismiss without prejudice. But they present this to the court. Most judges, not all, but most judges in Alabama, if we have answered the lawsuit, will say, now wait a minute, let's see if the defendant wants you to dismiss without prejudice. And if we object, then it just goes to trial. And now other judges, hey, I'll dismiss it without prejudice, no problem. So if you get the opportunity, you may want to fight it or you may want to accept it. It is a victory, okay? I mean, no doubt about it. There was a lawsuit against you and now it's gone. It's just they can sue you again. That's the downside. And there's been no adjudication on the merits, right? Like a dismissal with prejudice. Without prejudice, it's not a determination on the merits, so they don't have to take it off your credit report. But here's what they do have to do. If you filed an answer and said, I dispute owing this debt, or I deny the allegations, that is the ultimate dispute letter. Well, if this is a debt collector, a debt buyer covered by the FDCPA, Fair Debt Collection Practices Act, then Section 1692E8, that's under Section E, which is for misrepresentation, and 8 is an example of that, false credit reporting. Well, what's an example of false credit reporting? Knowing an account is disputed, but not marking it as disputed. Now, courts have added a requirement to say they have to update your report after the dispute. So here you dispute it, and then maybe the next month or next week or whenever they update your report and they don't mark it as disputed, then they have almost certainly violated Section E8. So if they dismiss it without prejudice, yeah, they can sue you again, and we'll talk about whether they do that. But you may have a claim against them under E8. So I would definitely look at your credit reports. As I'm recording this, we're in February, and you can still pull your reports for free from annualcreditreport.com once per week. Now, sometime in April, the end of April, I guess, that supposedly is ending. But you can still pull them once a year from annualcreditreport.com. And you can go to like myequifax.com, Experian.com, pull them for free. And so I would definitely do that. Now, final thing I'll say is, will they sue you again? Well, it depends. Has the statute of limitations run out? If it has, and they really can't sue you, I'll say this. overall, I think it's unlikely that they sue again. I mean, there's some reason they dismissed the case. They thought there was some problem. Maybe they're unprepared for trial. Maybe in the chain of title from the original creditor to this company, to this company, to this company, to the plaintiff, maybe there's some problem in this chain of title and they go, we don't feel real good about this. Or a problem with the document. So there's some reason they paid to file the lawsuit and now they're dropping it. So the odds are they won't sue you, but I will say this, if you don't have a lawyer, I think it's more likely they sue you. If you have a lawyer, sometimes they dismiss without prejudice because they realize, okay, your lawyer knows what he or she is doing, and they just assume, well, if we sue you again, you'll go back to that lawyer. And so it's certainly possible they could resue you, but again, it is a victory because they did drop the lawsuit. And again, check that credit reporting and just be very observant. Somebody knocks on your door, you start getting advertisement letters from lawyers, don't ignore that. That may mean that you've been sued again. So hope that is helpful. And Kenneth, I appreciate that great question. And you guys keep the questions coming and I will answer them whenever I have a chance. Okay, thanks a lot, guys. Bye-bye.